All rise.
Just before we commence the process of entertaining oral submissions, the Commissioners would like to make a statement the process which we will follow is that you are at liberty to remove your face mask when you are speaking, but at other times it would be advisable for us all to continue to wear our masks. The Perth Casino Royal Commission now enters the final phase of its inquiries. Today and tomorrow we will hear oral closing submissions from interested parties who have requested leave to do so. We will then prepare our final report that is to be delivered to the Governor and to the Premier no later than the 4th of March 2022. Before we call on the first of the interested parties to make an oral closing address, the Commissioners wish to make some comments about the procedures that have been adopted during the later stages of the inquiry. The time frame for the later stage of the inquiry, indeed for most of our deliberations, has been tight. The evidentiary phase of the inquiry effectively ended on the 19th of November 2021, although the process of finalising lists of exhibits continued through November and into early December. On the 17th of December 2021, interested parties were provided with the Commission's written closing observations, which had been prepared by counsel and solicitors assisting with some input from the Commissioners. On the 20th of January 2022, responsive closing submissions were received by the PCRC from interested parties, and the PCRC then distributed those responsive submissions to other interested parties. On the 27th of January, some interested parties took the opportunity to deliver reply submissions to the responsive submissions of others of them. PCRC was cognisant of the demands of their schedule, especially since it fell across the holiday season, but the final reporting date is such that there were no feasible alternatives. The Commissioners are grateful to the parties for their written submissions, which have been of assistance. They've been considered and will be looked at again in the light of what is said over the next couple of days and generally in the course of finalising the report. The final report will include a chapter explaining the methodology and processes that have been utilised during the inquiry. However, we wish to take this opportunity to make a few short remarks by way of summary of what that chapter contains to explain to those who are observing the process how it developed. The processes adopted during the final stages of the inquiry may be different from other inquiries with which observers may be familiar. This is due to what the Commissioners believe was the most practical way to deal with the significant amount of material that had to be considered in a tightly compressed time frame and a way that is fair. And in this context, we use the term fair both in the technical sense of procedural fairness and generally in accordance with broader notions of fairness. The PCRC has been conscious of the expectations that as much as possible of its inquiry should be conducted in public so members of the community can be informed about the process. We have not taken lightly decisions that have been made that limit public access to inquiry material, but as will be explained shortly, the intention is to put as much as is possible into the public domain by the end of the process. The requirement of fairness has been paramount consideration in all of the PCRC's work to inquire into and report on its terms of reference. The way that this has been done will be explained in detail in the final report, and it will cover fairness at all stages of the inquiry. And this inquiry is, of course, many-faceted, and it has been going since March 2021. What I'm about to say is only a brief summary of some particular aspects that have arisen in the later stages, namely the period since November 2021. There are at least 5 aspects of the procedures adopted in the later stages of the inquiry that the Commissioners believe are integral to the provision of fairness. The first is the production of 4 discussion papers on various topics. In relation to 2 of them, namely the regulatory framework and the issue of poker machines and electronic gaming machines, the Commissioners formed the view that they may be of particular interest to members of the public who might wish to make submissions about them. They were therefore included on the Commission's website. The other 2 discussion papers, namely on the technical concept of suitability and on structural issues arising from the corporate and trust structures of the Birthwood entities, were thought to involve matters peculiarly within the province of the interested parties, and they were not made public. The interested parties have had the opportunity to make submissions on all or any of these, and some of the interested parties have done so. The second relates to the tender of documents. During November and into December, the PCRC afforded to the parties an opportunity to tender documents that they considered relevant to the inquiry and to seek non-publication orders in relation to any documents. Following this process, the PCRC provided parties with a composite list of documents that had been tendered and that were therefore evidence in the inquiry. The third matter relates to the PCRC's written closing observations and the parties' responsive submissions. The PCRC's document covered many things. A primary purpose of the document was to identify issues that solicitors and counsel assisting with some input from the Commissioners believed might be considered in the final report, and to notify the interested parties of potential adverse findings arising from those issues. The parties were then at liberty to provide submissions responding to matters raised in the written closing observations document and to put forward counter-arguments and material considered to be relevant. Importantly, they were also given the opportunity to address matters raised by the other interested parties and that they felt affected their interests. The fourth relevant aspect is the process of oral closing addresses on which we are about to embark. All interested parties were given the opportunity to speak. Most have elected not to do so, and none who applied for leave were refused. Because of the short period for us to finalise the report, we could only allocate 2 days to the process and have found it necessary to impose time limits on the presentations, which are happily in line with the estimates given by the respective parties. The oral closings will be an opportunity for those parties to explain to the public and to the Commissioners what they consider to be the most significant factors and how they see those matters affecting their interests. At the end of the party submissions, counsel assisting may make some observations on procedural issues or that she considers to be appropriate by way of response to the party's oral submissions. Those matters aside, and in accord with the Commissioner's approach to procedural fairness, it is not intended that counsel assisting will raise matters in her address that have not been notified to interested parties. The fifth and final aspect we wish to mention relates to the process of written closing observations and submissions. At the time of the provision of the closing observations, the PCRC had not reached any final views, and indeed, in some critical matters, that remains the position. The nature of this inquiry means that it was not possible to ask every witness about all matters that might be the subject of adverse findings during the hearings. Some matters came to light in the course of the evidence given by other witnesses or the PCRC's other investigations, some of which were and must remain confidential. For that reason, the closing observations document was a comprehensive record of the matters that had been inquired into and the possible basis for potential findings. Similarly, the responsive submissions of interested parties covered matters germane to the issues raised in the PCRC's document and which in some cases traversed matters affecting other parties that might not previously have been raised in a public forum. The written closing submissions and the parties' responsive submissions were not made public because the PCRC had not had the opportunity to hear submissions from the interested parties at that time. To make public potential findings, that is, findings that were seen to be open, but that the Commissioners might not make in the final analysis, without the opportunity for those parties to be heard, carried the risk of unfair and avoidable consequences for individuals and organisations named in closing observations. Because it was not feasible to separate out parts of the interested parties' closing submissions that went to similar matters, the decision was taken not to make those documents public either. However, it is important to explain that the decision not to make the documents public at this stage was not reached with a view to shielding individuals or organisations from the consequences of conduct that is found to the requisite standard to call for approbation or adverse comment. It's a question of timing. Once the commissioners have reached a level of satisfaction about those matters, they will be made public. The time and place for that is the final report rather than the preliminary process of closing submissions. The analysis and conclusions in the final report will represent the informed and considered views of the three commissioners based on their assessment of all relevant materials. It is, of course, for the government, not the PCRC, to decide when and how the report will be made public. But if it follows the normal course, there should not be a long delay after the report's been delivered. Another aspect of the closing observations requires explanation. In many inquiries, the inclusion of the evidence gathering process is followed by oral submissions from counsel assisting the inquiry after or at the time of delivery of written submissions. This is not the process the PCRC has adopted. There are many reasons for the departure from this process, and I'll mention two. It was considered to be a better use of time, which is an extraordinarily scarce commodity. It was also considered more appropriate, given the working relationship between the commissioners and solicitors and counsel assisting, for the comprehensive written closing observations summarising the evidence and recording potential findings. The document was prepared by counsel and solicitors assisting the PCRC with input from the commissioners. The objective was to give the parties an opportunity to respond to the written materials before matters were addressed in oral submissions by counsel assisting. This process minimises the risk of potentially damaging claims against an individual or an entity that may not be accepted by the commissioners being made in public oral submissions. But we repeat, the selection of this process was not designed to and does not deny the public the opportunity to know what the PCRC's inquiry has found. The Commissioner's analysis of the evidentiary materials and their reasoning process leading to conclusions and the findings that the three of us have made will be set out in full in the final report. Repeating that in these remarks we are concentrating on fairness issues in the later stages of the inquiry, the 5 mechanisms that I've mentioned together represent a composite suite of measures by which procedural fairness and fairness generally are afforded to interested parties. It is not at odds with the legitimate expectations of the public to reach an understanding of the process and its results, which will be made clear in the final report. Now, we'll move to our oral closing. Ms. Seawood, the process which we would prefer to follow is what we've done throughout the inquiry, which is to allow you the freedom to develop your submissions, and then we'll dialogue with you and ask questions at the end if that's suitable.
Yes, that is convenient. May it please the Commission. The Department is grateful to the Royal Commission for granting it leave to appear today and make these closing submissions. The Department considers that it is important, given the public nature of the Royal Commission and the hearings to date and the subject matter of this Royal Commission, that the Department provide closing submissions in a public forum addressing matters that are specific to the Department. The Department proposes to provide submissions which provide a short overview of some of the key topics concerning the role and function of the Department, the steps taken by the Department in response to matters raised in the Royal Commission, and finally to respond to matters raised in the other reply submissions. At the outset, we note that the Department makes these submissions on its own behalf and not on behalf of the government or the broader public sector. The Department's submissions therefore do not represent the current or intended policy directions of the state government. The first topic I will address is an overview of the relationship between the Gaming and Wagering Commission and the Department and the role of each. An understanding of this relationship is relevant to Terms of Reference 10. The roles of the GWC and the Department in relation to the regulation of casino gaming and the Perth Casino are defined by the statutory framework within which they operate. Accordingly, in order to understand the respective roles of both the GWC and the Department, it is necessary to have regard to the key features of this statutory framework. The department has addressed the key themes evident from a review of the statutory framework in its written closing submissions. I will not repeat that analysis in detail here today. However, what we respectfully submit is that it is clear from the statutory framework that the department and the GWC have distinct and separate roles, whilst also working together to achieve the objects of the overall framework. The GWC is established under the Gaming and Wagering Commission Act of 1987 as a corporate body and is capable of doing and suffering all things that bodies corporate may lawfully do or suffer. Subject to the Minister, it is the function of the GWC to carry out the administration of the GWC Act. Section 7 of the GWC Act identifies a number of duties of the GWC. Some of these include, firstly, administering the law in relation to gaming, secondly, formulating and implementing various policies, thirdly, to administer all matters relating to any casino complex, licensed casino, casino key employee, casino employee or gaming in a casino pursuant to the Casino Control Act 1984, and any casino complex agreement. Fourth, to cause licences, permits, approvals, authorisations and certificates as appropriate to be issued. And fifthly, to perform such other functions as are prescribed by or under the GWC Act or any other written law. Other written laws would of course include the Casino Control Act and the relevant State Agreement and State Agreement Act. Turning to the Casino Control Act and the various regulations made under it, it provides for the performance by the GWC of a number of other functions concerned with casino regulation. Some of these include, first, declaring games to be authorised games for the purposes of Section 22. Second, approving various matters including casino key employee and casino employee licences, and also approvals in relation to controlled contracts. And thirdly, hearing applications for review of banning notices. And the GWC also has responsibilities under the State Agreement and the Casino Burswood Island Agreement Act of 1985, including matters that have generally been described as probity approvals. What we submit is clear from a review of the statutory framework is that the GWC is the statutory body that has been charged with the administration of the law in relation to casinos and casino gaming, and it is the GWC who is the decision maker for those matters. Turning to the department, sections 18 and 19 of the GWC Act provide a number of different ways in which the GWC may engage or make use of staff. One of these is that the GWC may come to an arrangement with an employing authority to make use of staff in the public service or in a state agency, and also to make use of the facilities of a department, agency or instrumentality. The Royal Commission has heard during its evidence sessions that the GWC has never directly employed officers to assist it and has instead always come to an arrangement with the employing authority of the department under Section 18 of the GWC Act. The department has undertaken this role since 14 December 1984, when it was first established as the Office of Racing and Gaming, supporting the then Casino Control Committee and later the Gaming Commission, as the GWC was then called. Over time, the department has had a number of name changes, but the department has existed in its current form since the machinery of government changes in 2017. What a review of the statutory framework establishes is that it is the role of the department to support and assist the GWC in the exercise of the GWC's statutory functions. The department itself is not charged with any statutory decision-making role in the same way as the GWC is. Insofar as the department supports the GWC, that support can broadly consist of the department, through its officers and employees, first undertaking GWC's administrative tasks. Secondly, performing audits and inspections and associated compliance reporting. Third, undertaking any required procurement and contract management. Fourth, providing technical and IT services. Fifthly, undertaking policy development work. Sixth, providing services and controls. 7, preparing and carrying out communications on behalf of the GWC. That is including with Perth Casino, with the Minister and other external agencies. And finally, preparing of meeting agenda papers and then executing or giving effect to the resolutions or decisions of the GWC. The department's tasks are, of course, not limited to supporting the GWC, and nor are they limited to assisting the GWC in relation to only casino regulation. As the Royal Commission heard, the GWC has broader powers. The Royal Commission has heard that the main interaction between the GWC and the department occurs at monthly GWC meetings. For these meetings, departmental officers prepare an agenda and put forward agenda papers on a wide variety of topics for the consideration of the GWC. The GWC then considers the matters put forward in the agenda papers and makes a decision as to whether or not to approve the proposal put forward. At all times, it is for the GWC members to review the agenda papers with a critical eye and bring their own independent mind to the matters raised for their consideration. All GWC members who gave evidence in this Royal Commission understood this aspect of their role and agreed that they were not obliged to agree with the proposal merely because it was put forward by the department. All GWC members understood that they could ask questions or ask for more information, and all GWC members in their evidence understood that they could request matters to be added to a future agenda. Therefore, respectfully, the department agrees only in part with paragraph 6 of the GWC reply submissions. The department agrees that it has particular responsibilities to instigate policy development and monitor emerging regulatory issues. The department also agrees that it has a responsibility to provide clear, cogent agenda papers for the consideration of the GWC. Those agenda papers should provide policy options and information and provide the relevant statutory and policy context. However, at all times, these activities are done on behalf of and in consultation with the GWC. This is because the department is not the statutory decision maker. Rather, it supports the GWC and works together with the GWC. Therefore, the department submits it's also incumbent on the GWC members to undertake their statutory role and critically review and consider the agenda papers put forward by the department and request additional information, including policy options that the members feel are relevant to their decision-making process. I next wish to make some short submissions on the standard relevant to the findings to be made by the Royal Commission. The Royal Commission is required by term of reference 10 to consider and report on, amongst other things, the capability and effectiveness of the department in supporting the GWC, including in relation to identifying and addressing any actual or perceived conflicts of interest by officers involved in casino regulation. In so doing, the Royal Commission has had cause to consider the actions taken by the department and departmental officers over a wide period of time, in some cases over 10 years ago. When assessing the effectiveness of the support provided by the department to the GWC, the department respectfully submits that it is appropriate for the Royal Commission to consider the various matters referred to in paragraph 303 of its written submissions, including, firstly, the statutory framework within which the department and the GWC operates. Second, the fact that some of these events occurred some time ago, and it's reasonable for individuals not to recall such events with perfect clarity. And finally, that the Royal Commission is in the position of being able to gather a suite of historical documents and consider the cumulative effect of each in a manner that may not have been practical or possible for the individual departmental officers involved at the time. The department also joins with the other interested parties in respectfully submitting that in the event the Royal Commission proposes to make findings about the conduct of individuals, whoever they are, that first, findings of culpability should be made with great care, applying the Brigginshaw standard. Secondly, the Royal Commission should be wary of making findings using hindsight reasoning. And finally, such findings should be made, if required, only if required, for the purposes of the terms of reference. The next topic I wish to address is the improvements that have been made to the corporate governance and regulatory framework. The staff of the department have a number of roles, some of which include supporting the GWC in the performance of its statutory duties, one of those being the regulation of the Perth Casino. The department respectfully submits that staff have done their best to adapt to the changing and challenging circumstances facing the department in recent years and have undertaken their duties to the best of their ability. Notwithstanding our submission that individual staff have done their best in the performance of their duties, the department has acknowledged in its written submissions and acknowledges here today that aspects of the quality of the support provided to the GWC prior to the establishment of the Royal Commission could have been better. The department therefore does not accept the submission of Crown at paragraph 127 of its reply submissions, that the department has not made concessions about its own conduct. The department has taken a number of steps commencing in 2021 to improve the quality of the support provided by the department to the GWC and to assist the GWC in better performing its statutory roles. These improvements can be divided into two categories. First, improvements to assist the GWC to develop and implement its strategic work program, and secondly, improvements to the department's own corporate governance. Turning first to matters relating to the GWC. A GWC Strategy Planning Day was held in June 2021, from which a GWC Strategic Work Program was developed. The Strategic Work Program identified 4 critical areas of focus for future work. They are first, the governance framework. Broadly, this concerns the identification and development of the suite of government instruments relating to the GWC's practices. Secondly, the regulatory function, which involves undertaking scoping and formalising the operational relationship between the GWC and the department. Thirdly, stakeholder and community engagement, including the development of a GWC communications plan and identification of current programs of work to discharge responsibilities in relation to harm minimisation. And fourthly, continuous improvement and business intelligence, including undertaking skills gap analysis of GWC members. The focus of the GWC and the department to date has primarily been on matters concerning the first 2 of those critical areas, the governance framework and the regulatory function. Some of the key developments to date have been as follows. First, the development and approval of the GWC Strategic Work Program. Second, the establishment of a dedicated GWC Secretariat to provide governance and meeting support to the GWC. Third, the development and endorsement of an updated GWC Code of Conduct, an updated GWC Conflict of Interest Policy, and a new GWC Gifts, Benefits and Hospitality Policy. The Register of Conflicts is now tabled at each GWC meeting, and a Register of Gifts, Benefits and Hospitality has now been established. Fourth, an increased focus on the quality of the agenda papers and the minutes for GWC meetings. The improvements to the agenda papers have been commented upon positively by GWC members. Fifthly, the development and endorsement of an interim casino compliance strategy, the confidential details of which have been provided to the Royal Commission. Sixthly, the development of an updated and more comprehensive induction package for new GWC members. The department accepts the point made in paragraph 13 of the GWC responsive submissions that it is the quality of the induction package and its utility to the GWC members that is relevant. For this reason, the department has worked with the GWC to identify the elements of the proposed induction package, and a draft will be presented to the GWC at the February 2022 meeting for GWC consideration and endorsement. Seventh, a draft GWC governing body charter has been prepared and will be presented also at the February 2022 meeting. Eighth, more detailed financial reports are now provided to the GWC, and the Chief Financial Officer now attends the monthly GWC meetings to be available to answer any questions. In relation to problem gambling and harm minimisation, the department and the GWC have jointly engaged an experienced regulatory consultant to develop a policy model providing options as to how Western Australia may better respond to gambling-related harm. That report is pending. In the meantime, the Problem Gambling Support Services Committee now provides monthly updates on its work program to the GWC. The department has also developed a terms of reference for the Problem Gambling Support Services Committee. That has been endorsed by the committee and also the GWC as a working document, which will be used pending the development of the policy model. And finally, GWC members have also been offered a number of training programs or professional development opportunities, including accountable and ethical decision-making training, attending workshop sessions on navigating current challenges in regulatory practice conducted by Harvard Professor Malcolm K. Sparrow, and the option to attend virtually the International Association of Gaming Regulators Conference held in Boston in September last year. To support these enhanced training opportunities, the department will also be working towards developing a paper in the first half of this year addressing the development of a skills matrix for the GWC. Department notes that it remains open to individual GWC members to also identify other areas of training or professional development which they may wish to attend. The department reports monthly to the GWC in relation to its progress regarding the strategic work program, and a second strategic planning day is scheduled for April 2022. Turning to the improvements to the department's own corporate governance, the department has taken a number of steps to improve various aspects of the department's processes. Firstly, the implementation by the Director-General of an interim executive structure that was approved by the Public Sector Commissioner for the department. That interim structure includes the creation of 2 Deputy Director SES level positions. Second, the creation of a new Executive Director of Strategy, Accountability and Performance position. Third, the creation of a new Executive Director, Racing, Gaming and Liquor position. This position is responsible for regulatory design and building the capacity, outcomes and integrity of the racing, gaming and liquor portfolio. The incumbent is also the Chief Casino Officer. And finally, the secondment of an Executive Manager to the Secretariat position for the GWC. Acting appointments to all these positions have been made, and the interim structure remains in place and is currently approved until June 2022. Second, finalisation of the internal review by Fiona Roach into the Racing, Gaming and Liquor division of the department occurred. This internal review commenced in December 2020. Thirdly, the Casino Compliance Branch has increased the presence of inspectors at the Perth Casino. Fourth, within the Casino Compliance Branch, a new Casino Regulatory Reform Program team has been established to address issues identified during this Royal Commission. Departmental officers have also completed a number of training programs, including the Accountable and Ethical Decision-Making programs, Conflict of Interest training workshops, and the same Navigating Current Challenges in Regulatory Practice workshop sessions referred to previously. Sixth, the department has ensured an experienced regulatory and management consultant has been engaged to provide expert and strategic advice to the Chief Casino Officer and other senior officers of the department as and when required. Seventh, an interagency working group, an operational group on casino tax, has been convened to consider a number of issues surrounding the payment of casino tax by the Perth Casino. This working group not only includes officers from the department, but also officers from the departments of Treasury and Finance. Eighth, an external consultant has been engaged to improve the audit capability of the department generally. Ninth, an external consultant has been engaged to undertake a review of the funding of the services provided by the department to the GWC. That is, to review the department's service fee. This review will include the development of an activity-based costings model, which will in turn inform a more accurate calculation of the department's service fee to the GWC and assist in the development of a written service level agreement between the department and the GWC for the start of the 2022-23 financial year. 10th, the department has commenced a series of communications from the Director-General regarding the department's code of conduct and the various principles contained in it. And arrangements have been made for integrity presentations to be given to the department's corporate executive by the Corruption and Crime Commission and the Public Sector Commission. The department has accepted and accepts today that its historical management of conflicts of interest was not of the standard expected of a modern public sector organisation involved in regulation. The department has taken a number of steps to address this issue. In February 2021, the then acting Deputy Director-General of the department requested departmental officers advise her of any personal relationships or close friendships with staff at Crown Perth. Such personal relationships or close friendships were then declared, assessed and managed in accordance with the department's code of conduct, including the development of a mitigation strategy. Those conflicts and the mitigation strategies for staff involved in casino regulation were reported to the GWC in May of 2021. In August of 2021, the Director-General approved a new Managing Conflict of Interests guidelines for the department. Thirdly, a centralised online register of declared conflicts of interest and the associated approved management plans now exists. The register is tabled at the department's corporate executive meetings each month. And finally, a new centralised online register now also exists for gifts, benefits and hospitality, with a review of the department's gifts, benefits and hospitality policy and guide scheduled to be completed by June 2022. The department's work in relation to these matters will continue to evolve and develop as time progresses. I now wish to make some short observations and submissions in relation to some specific matters raised in the other interested parties' reply submissions, to the extent I've not already addressed those so far. Turning firstly to some matters raised in the GWC's reply submissions. At paragraph 15, paragraph 15 of the GWC's submissions deals with the extent to which the department is presently able to assist the GWC in a review of the key performance indicators. In our respectful submission, the GWC's submission oversimplifies the issue of a review of the KPIs. The GWC assert that the department does not have a developed view and is not able to presently provide advice and policy support in relation to this issue. The evidence heard in this Royal Commission has made it clear that the GWC has been lacking a number of strategic and governance documents. These have been identified in the GWC Strategic Work Plan and are currently being developed by the department on behalf of the GWC. These strategic and governance documents need to be developed before the department can undertake or cause to be undertaken a meaningful review of the GWC KPIs and provide meaningful policy advice on this issue. Paragraph 108 of the department's written submissions outlines this process. Therefore, the department respectfully submits that when regard is had to the entirety of the work the department is currently undertaking in support of the GWC, it is providing advice and policy support in relation to the strategic objectives of the GWC, and this work will inform the future review, consideration and advice regarding the key performance indicators. We wish now to turn to the topic of the changes to the electronic gaming machine policy that were made in 2019. This matter is addressed at paragraphs 45 to 46 of the GWC reply submissions. The department accepts and has accepted that the electronic gaming machine policy should not have been amended in 2019 to remove the prohibition on multi-line outcomes, also known as winning combinations. At paragraphs 383 to 387 of the department's written submissions, it posited an explanation, not an excuse, as to how that outcome came about. The GWC in its reply submissions takes issue with that explanation, on the basis that the changes requested included a change to the return to player, which was not approved, and a change in the speed of play generally, which was also not approved in the form put forward in the recommendation. However, respectfully, we submit that when regard is had to these particular minutes and agenda papers, these two matters don't alter the submissions made in our written submissions. What is clear from a review of the various documents is that the original proposal that was put forward by Crown and therefore the department to the GWC did include a change to the return to player, plus a change in the speed of play and some associated other amendments, including the independence of outcomes. When the matter was first considered by the GWC in March 2019, a decision was made to split in half the matters for consideration, the return to player being the subject of consideration by the Minister or possible consideration by the Minister, and the other matters to be the subject of a paper put forward by the department to the GWC. I don't know if the Commission has this particular document in the bundle, but the minutes of the GWC from 26 March 2019 are found at gwc.0002.0016.0271. If we turn to page 4, what first happened, at the bottom of the page, item 6.4, there is a reference made to a presentation being given by Crown in relation to the agenda paper. And then the resolution is to note the presentation. In addition, the chairman to provide a briefing to the Minister for Racing and Gaming regarding Crown Perth's request. The matter then came before the GWC in the April 2019 meeting. The minutes are located at gwc.002.0016.0273. On page 2, under item 5, business arising. In the second paragraph, it can be seen that the DC, being Deputy Chair, referred to agenda item 6.4, which is the one I've previously taken the Commission to. The Deputy Chair is then asking members for further guidance in relation to the proposed amendments sought by Crown Perth, and it lists there the 3 bullet points of what those are: reduction in the minimum game speed, changes to game design features, reduction in return to player. In the following paragraph after the bullet points, the members agreed that in relation to the reduction in game speed and the changes to game design features, these proposed amendments be progressed through a submission of an agenda paper for the consideration of members at the Commission meeting in May, whereas the reduction in return to player is dealt with in the next paragraph to be discussed with the Minister. The matter did not come back before the Royal Commission before the GWC in May of 2019. It did come back in July of 2019. The relevant agenda paper is gwc.002.0016.0281. On the first page, it outlines the background to the proposal put forward by Crown and recounts the history of what has happened to date at the various meetings. If we go over to page 2, and if we could blow up the paragraph immediately above the word recommendation. Amended version of the WA appendix relating specifically to factors 1, subparagraph 4 and 2 only, attachment 4, and corresponding sections of the EGM policy at attachment 5 have been attached for the consideration and approval of the Commission. So attachment 5 contains the EGM policy, and that can be located on page 32. Thank you. So page 33 contains the beginning of the marked up amendments that have been submitted for consideration and approval by the GWC. We can see amendments proposed to appearance, speed of play, winning combinations, which is number 4, and over on page 34, independence of outcomes. So that was what was put up to the GWC for its consideration. If we turn to the minutes from July, they can be located at gwc.0002.0016.0285. Relevant page being page 2.
Perhaps just before, sorry to break with the procedure that we all agreed upon. Going back to the previous document, where do you say the multi-line
Yes.
changes appear in
So
that document, if at all?
We're on, yes, on page 33. Sorry, operator. Item 4, winning combinations. It lists the different combinations that are or aren't acceptable.
And you're proceeding on the basis that the application requested changes to game features and the removal of the prohibition on multi-line was a change in game features, is that right?
Well, we accept that it's not clear, and we've accepted that in our written submissions. What we are simply putting forward is an explanation for how it came about. And how it came about is this was the paper that was put up for the GWC's consideration and approval.
All right, thank you. Then please continue.
If I could turn back to the minutes from July, which were gwc.0002.0016.0285 and on page 2. It's agenda item 5.3, reduction in minimum game speed. The confusion that has clearly come about is when a review of the formal resolution in the box and the paragraph above are considered. The department accepts that the formal resolution is to approve changes to the WA appendix and relevant policies to reduce the minimum game speed to 3 seconds, and then it provides some details about game speed and also remove references from documents relating to the independence of outcomes. And the department accepts it doesn't refer to the winning combinations. However, when regard is had to the paragraph above, members agreed to approve the changes requested, including those related to game design and independence of outcome, and requested the minister be briefed in relation to this proposal. In our respectful submission, what is unclear is what else was being approved. If it says agree to approve the changes, including those, it begs the question of what else was being approved. The submission from the department is simply that this is the explanation to the best of the department's ability as to how the policy came to be amended in circumstances where it's not specifically referenced in the resolution of the GWC. Turning to paragraph 50.4 of the GWC reply submissions, which is simply a submission in relation to the department's position on harm minimisation. The department simply wishes to confirm that the department does not suggest it was entitled to be wholly or even substantially reactive to requests for support and assistance from the GWC. Rather, when our paragraph 253 is read, the department is saying that the existence or non-existence of a request from the GWC to develop a particular policy is simply one factor that is relevant to considering the effectiveness of the department's support in relation to the topic discussed in that paragraph. Turning briefly to the reply submissions made by the Crown entities, at paragraph 113 to 115 of the reply submissions is a discussion in relation to the speed of play for EGMs. The department accepts the point made by Crown in those submissions that it has not conceded that it is unable to verify the average speed of play, but rather has identified the need for an agreed methodology as to how speed of play is tested, both pre-approval and post-approval. The department maintains its primary submission that it is open to this Royal Commission to recommend that the GWC consider restoring the WA Appendix and the EGM policy to their pre-July 2019 text. The department agrees that if the GWC moves beyond restoring the Appendix and the EGM policy to their pre-July 2019 text and considers revoking any relevant declarations that have been made in the interim period, then it will be required to follow the show cause procedure set out in Section 22 of the Casino Control Act. The next topic the department wishes to address is the role of the department after the conclusion of this Royal Commission. The final report of this Royal Commission will make a number of findings and recommendations in relation to parts A and B of the Terms of Reference. The department has made limited submissions in relation to Part A of the Terms of Reference. The department looks forward to the Royal Commission's findings and recommendations in relation to this part, and it will support and assist the GWC in reviewing and considering those findings and recommendations and taking such action as the GWC considers appropriate moving forward. In relation to Part B of the Terms of Reference, insofar as the Royal Commission's findings and recommendations concern the effectiveness of the support provided by the department to the GWC, the department has not stood idle waiting for the Royal Commission's final report. As outlined in our written submissions and summarised here today, the department has taken steps to address many of the issues highlighted in the evidence before the Royal Commission and identified in the interim report. This program of work includes matters specific to the department and matters assisting the GWC. These programs will develop and evolve following the receipt of the final report and a consideration of the matters raised in it. The second part of Part B of the Terms of Reference concerns enhancements to the regulatory framework. The evidence before the Royal Commission has identified a number of areas of potential recommendations in this respect, and the interested parties have addressed many of those in their responses to the regulatory framework discussion paper. Some of these matters, such as the inclusion of an objects clause in the legislation and the appointment of an independent chair of the GWC, have received universal support. Others, such as the appropriate regulatory model and the regulation of electronic gaming machines, involve more complicated and nuanced considerations. There has not been a review of the legislative framework governing the regulation of gaming since the Government Gaming Inquiry Committee review and report in 1984, which led to the creation of the Gaming Commission. This Royal Commission has provided an opportunity for reflection and engagement in relation to the current framework and, if appropriate, an opportunity for law reform. Ultimately, the Royal Commission's recommendations in this respect will be matters for the government to consider and respond to. The department looks forward to carefully reviewing and considering the Royal Commission's recommendations as part of its role assisting and advising the Minister. Those were the submissions of the department, unless there are any questions from the Commission.
Ms Seward, can I ask you some questions about the current situation with the Casino Control Officer? Is there currently a permanently appointed Casino Control Officer?
No, there is not. The previous acting person in that role, Ms Larkham's 6-month contract came to an end and unfortunately was unable to continue in that role. A new person has been appointed to the role of Executive Director of Racing, Gaming and Liquor, and that person is currently in the process of being appointed as the Chief Casino Officer.
Is that Ms Perry or someone else?
Ms Jennifer Shelton.
And sorry, she's in the process of being appointed.
She has taken up the role of Executive Director of Racing, Gaming and Liquor, which is the underlying department position. There needs to be an authorisation then under the Casino Control Act Section 9 to appoint Ms Shelton as the Chief Casino Officer. That authorisation still has to be completed.
Sorry, could I just follow through on that? Where in the hierarchy, the departmental hierarchy, where does the level of Executive Director fit? say in relation, we're used to the phraseology Director General.
Yes.
Deputy Director General, who's generally held the role of CCO.
Yes, so the hierarchy, the current structure is that we have the Director General, the top, then we have 2 Deputy Director Generals, and sitting below one of those Deputy Director Generals is the Executive Director level. So it's the 3rd level down, describe it that way. It is, the first 2 levels are the Senior Executive Service, the Executive Director is the Permanent Public Service.
So I gather from that Ms Shelton, as far as the department and Ms Shelton is concerned, is going to be appointed the permanent CCO?
Yes, those are my instructions, yes.
And is it still the, as I understand it, the department's position that it's the role, obligation, duty, however you want to phrase it, of the department to appoint the CCO?
That is certainly an issue that has been raised in this Royal Commission, and the department's present view is that under the Act it simply doesn't say who appoints the Chief Casino Officer. So unless and until that matter is resolved, the department's current position is that it is appropriate for the department at this point in time to continue to appoint the Chief Casino Officer. When I say department, I should say the Director General, as the employing authority of the department, is the appropriate person to appoint unless and until consideration of that issue can be further dealt with.
Now, seeing that this appointment, seems to be in train, what then is the GWC's role in that appointment? Does it get an opportunity either to be consulted or to veto the appointment?
Don't have instructions on what the particular role will be in relation to the appointment in relation to Ms Shelton, but certainly those matters are matters which will need to be worked out moving forward. When Ms Chopping gave her evidence to the Royal Commission, she explained that she had put in place this interim structure to get the department through the period until the Royal Commission's findings can be handed down and some permanent decisions and changes, if necessary, can be made. So at this point in time, this is part of the interim structure that is in place.
Sorry, I won't go there. In respect to Ms Chopping herself, is she being permanently appointed?
I do not believe so. I don't have instructions on exactly where that process is in the course of the various steps.
You referred to the improvements to the corporate governance and regulatory framework, and you'll be aware that the PCRC was provided with a document as part of the departmental submissions in relation to that. And at paragraph 12 of that document, it says that the department provides licensing services for casinos. Can you explain to me how, under the regulatory framework, it is the department that provides licensing services?
Yes, what presently happens is under a delegation from the GWC, it's departmental officers that deal with the key casino employee or casino employee licences. So what doesn't come up before the GWC at every meeting is every casino employee licence application. That is delegated down and the department manages those due to the volume and numbers. Also, that is a broader, it has got casino, but also it deals with permitted gaming. So the licensing services that are referred to in that paragraph are broader and include community gaming matters.
Yes, I appreciate that. But in relation to the provision of casino licences, even in that situation which you've just articulated, isn't the work of the department still being carried out on behalf of the GWC?
Yes, we certainly accept that, and I don't believe paragraph 12 was intending to say it's only done by the department in its own right. The focus of paragraph 12 is more this is the interface between the department and various West Australians in the sense that this is where people may send their applications and who they may hear from. But we certainly accept it's done on behalf of and for the GWC.
Finally, in relation to the Problem Gambling Support Services Committee, can you just articulate what is the department's position there? Is that committee a subcommittee of the GWC or independent of it or part of the department?
It's, in our respectful submission, not a subcommittee of the GWC. It hasn't been established in accordance with the requirements under the GWC Act. So it has, based on its historical development, been something that the department has managed, bringing together various groups of people in order to identify policies and programs and fund those in order to support gambling-related harm in Western Australia. What its role will be going forward is partly a matter that the external consultant doing the review and the policy options will consider. There's been no change to the Problem Gambling Support Services Committee pending that review, as it may be a complete change is recommended in relation to how Western Australia as a whole deals with problem gambling.
So just make sure that I understood what you were saying there, that the department says that it is a committee which historically it has organised, so to speak.
I think organised is, respectfully, yes, the correct word. It's organised. It's had input from various different groups, but yes, the department has organised it.
So what? So you're saying that the department currently and historically has had the power to direct it, but that the GWC has not had that power and does not have that power?
I'm not sure we would agree that the department has a power to direct it in any way. It doesn't have any sort of statutory power that would allow the department to do that. And if it is not a subcommittee of the GWC, then the GWC has no statutory power in relation to that. The GWC has increased its involvement in the Problem Gambling Support Services Committee since this Royal Commission has started, in the sense that the Problem Gambling Support Services Committee now reports up to the GWC, so the GWC has a sense of what work is being done. And traditionally there has been a representative from the department on the Problem Gambling Support Services Committee. But given it is not a formally established subcommittee, it doesn't sit within any legal framework that would give anybody a power of direction.
You say that its future, so to speak, is being considered. So does that mean that the department at this point doesn't have a proposed future, a determined future for the Problem Gambling Support Services Committee?
Yes, that is correct. That'll be considered as part of an overall policy consideration of how best to address harm minimisation.
You spoke about the induction. I said that was the last matter, but just one other matter I wanted to cover off on. That's the induction program for GWC members. You spoke about an induction program being prepared and then being submitted to the GWC for its endorsement. Is that what I understood?
Yes, that's correct.
So I want to understand what you meant by endorsement and what the department sees its role in that as opposed to the GWC. Whose induction program will it be?
It will be the induction program for incoming GWC members.
Yes, but is it the department's program, which it has for the GWC members, or is it the GWC's program, which it has for itself?
Well, we would say it's the GWC's program, but it is being developed and prepared by the department, and it will be put forward to the GWC for them to review the elements of the package and what the suggestions are for the information that should be included, and to obtain feedback then from the GWC as to what other things they think they would like to see in the package. Some work was done in December on that as to what elements might be necessary, and that did go to the GWC in December. what's coming back in February is the culmination of considering all those matters and the department's proposal for the GWC.
So, to get to the nub of it, will the GWC have the ability to approve or reject that program, independent of the department?
Yes, with respect. And it may be that it's a case of approving certain elements or asking for more things to be included. So it may not be an approve or reject type scenario. It may be, yes, that looks appropriate, or no, we would like some other matters to be included.
In respect of the content of that program, you have identified that the GWC members were given the benefit of attending a seminar or talk by Mr. Sparrow. Sorry, I've forgotten his title.
Yes.
I'm sure he has one. Professor Sparrow. Now that he's obviously an expert in regulatory theory, that's an important part of the GWC's armoury of knowledge. Would you agree to have some knowledge about regulatory theory and what sort of form of regulation they might be implementing?
Yes, we do.
So is there anything to your knowledge in the proposed program to further that education for GWC members as part of their induction?
Do you mean in the induction package itself? I don't have instructions on to that level of detail, but certainly part of the strategic work program, one of the 4 categories, is an improvement in the training information that the GWC will have in order so the individual members can better perform their tasks. So certainly training and general knowledge building is part of the strategic work program as a whole.
Thank you, Ms. Seawood. Those were my questions.
Just a couple, if I may, on the enhancements, Ms. Seawood. You referred to an increasing presence of inspectors at the casino. Is there an associated increase in the number of inspectors or the amount of hours being devoted to casino inspections now?
I don't have the precise instructions
Just
on those
in general.
precise figures, but I don't believe there's been any new appointments to inspectors.
Yep.
But there's certainly an increased presence. I can obtain additional information about the hours if that would be of interest.
Just in general terms. And you mentioned an external consultants being engaged to enhance the audit capability. Is that the casino auditing?
It's the department's auditing as a whole, which will then impact upon the work it does for the GWC.
Okay, thank you.
Ms. Seward, could I bring you back to the regulatory framework discussion paper that was circulated in November, and the department made a submission for which the commissioners are grateful. The impression on reading that is that the department's the 4 models that were 4 delivery models that were included. The impression reading it is that the department favoured centring the regulation of the casino back into the departmental structure rather than a statutory body. Is that a fair reading?
The department's position in that regulatory, in the response to that paper, was that either of the 4 models could work in Western Australia, depending on exactly what amendments were made to the statutory regime. The department does not formally express a preference for any one of the 4 models, but what the department did do in our response was to identify benefits, disadvantages of the various models, and that in relation to Model 4, we do identify in there a number of benefits to that model and a number of ways in which that model may be, of all 4, more in line with some of the recent whole-of-government policy documents that have been released.
And it is a model that applies in at least one other state, we recognise.
Yes, in Queensland.
But if we decide to the contrary and decide that it should be a statutory body of some description, the question that immediately arises is whether it should have full-time dedicated employees, at least at the central level, and the person occupying the role of Chief Casino Officer, who you might term a CEO of the body, a CFO of the body, and also an administrative manager would be three, I would have thought, key dedicated full-time employees. Does the department have a position on that notion of key employees being dedicated to the statutory body, if that is the way that the regulatory framework, the recommendation for enhancement of the regulatory framework are modelled?
The department doesn't have a formal view on who exactly should be the key employed positions if that model is put forward. We certainly accept that those three would seem appropriate in all the circumstances, but we don't have a view on whether there are any others or how many should or should not be directly engaged.
Yes, well, the next question, of course, would be where the casino inspectors would fit. And in terms of the enhancement processes in which you've been engaged, was any thought given to a full and comprehensive service delivery protocol or memorandum of understanding?
Yes, a service level agreement, Commissioner, if that's how I understand it, setting out the formal relationship between the department and the GWC. Do I understand that to be your question?
Yes.
Yes, that is definitely something that the Director General wants to be developed, and the proposal is for something to be developed to start the 2022-2023 financial year. In order to do that, part of that work is dependent upon one of the external consultants who is currently at the moment reviewing the entire service fee and an activity-based system of costing, because the department's view is that that will be fundamental to underpinning the service level agreement. There will, of course, be other matters that will need to be worked out, but certainly a formal service level agreement is part of the work program the department is working on.
Thank you. I have nothing else. Ms. Seawood, thank you very much. Those submissions have been very helpful. Thank you. Thank you very much.
Please, Commission.
10 past.
I suppose it just depends whether Mr Evans wants to start now or after a break.
Mr. Evans, I think we might take a break now, and if we come back at 10 past 11 and start at 10 past 11, that suits you? And I presume that everyone is aware of the West Australian Industrial Relations Commission's rulings on access to the level 18. You follow them, no doubt. Thank you. And we'll come back at 10 past 11. be seated. Thank you, Mr Evans.
If it pleases the Commissioners. The Gaming and Wagering Commission, which I'll refer to for brevity as the GWC from now on, thanks the Commissioners for the courtesy of an opportunity to make oral closing submissions. Those submissions are informed by the approach taken by the PCRC to the publication of written submissions, which may affect the understanding by the public of the positions of parties who might otherwise only read the report. And there are therefore some matters which I wish to cover in elaboration of the written submissions, essentially for the purpose of public consumption. Other aspects deal more directly with the submissions which have been made. I don't propose to descend in any great detail into the pros and cons of what are, on my left side, more than 8 inches of double-sided, close-typed submissions in response and submissions in reply, which raise an enormous number of issues. But we will make submissions about the approach to the resolution of those issues for the purpose of the final report and some matters for which the GWC advocates. Before turning to the first topic, which is the GWC itself, I do want to extend, on behalf of the GWC, its thanks to the assistance provided by the Department and the Department's solicitors at the State Solicitor's Office in dealing with the issues in this Royal Commission. As Commissioner Owen indicated in his opening, this has been an exercise undertaken under enormous time pressures with vast volumes of materials. I think Council for Crown have indicated somewhere in their submissions a set of statistics giving some indication as to the scope of the task, and for the GWC it would have been simply impossible to deal with those issues without the assistance of departmental officers and the SSO in providing logistical and material support. And GWC is greatly indebted to GWC and Ms. Seward for that support. The GWC also wishes to acknowledge that since the commencement of the Royal Commission in particular, there have been considerable improvements in a number of aspects of the interaction between the Department and the GWC, and Ms. Seward has taken you to a number of those in relation to improvements in procedures, in the quality of materials prepared for the GWC, and in the progression of a number of initiatives, in particular in relation to strategic planning, for which GWC members have been advocating for some time. That, of course, is a question of the mobilisation of resources, and without being flippant, it's amazing what the searchlight glare of a Royal Commission will do to liberate resources within government. One of the issues for you in making recommendations in the final report will, of course, be resourcing on an ongoing basis to sustain the efforts of whatever regulatory body in whatever regulatory framework is recommended. And I'll turn to that a little later. In identifying, as Ms. Seward did, the range of support and assistance which is provided by the Department to the GWC, and it is acknowledged and we accept the accuracy of that general description. The question necessarily arises, well, what is the GWC which is supported? And there are some important characteristics of the GWC which need to be made plain and understood in understanding how the GWC has performed its role over many years, and in addressing Part B of the terms of reference when this Royal Commission comes to make its report. The GWC is a small board of no more than 7 members, plus its chair. Except for the chair, ex officio, the Director General of the Department, and for much of the time the Deputy Chair, who was also concurrently, for most of that time, the Chief Casino Officer. It is essentially a volunteer body. And in recent times, its members have been selected effectively from those who put forward their names as volunteers to serve on any government board in Europe. The Commission has heard evidence from that from the most recently appointed Commissioners bar 2, who were selected through that process of volunteering effectively for board membership within the panoply of boards that exist within government. Members have always been selected by government through the responsible minister, almost exclusively through ministerial office, and rarely, if at all, after consultation with even the Director General. Historically, without the involvement of the GWC itself, through a process which is opaque, with no defined selection criteria or skills other than the general requirement in the Act that they be persons of good character and relevant experience. And how that relevant experience has been defined and employed is not apparent. For all that, the members have over time displayed a variety of skills which has evolved from time to time during different periods of the GWC. At one stage it had an emphasis, perhaps in the 2000 to 2010 period, on some gaming and hospitality experience. And in that time a particular interest in relation to issues of responsible gaming. More recently, the appointments have tended towards significant professional skills with chartered accountants, financial planners, former police officers being appointed. Only in the most recent appointments during the term of this Royal Commission have professional casino regulators been appointed as ordinary members of the GWC. One to replace Mr Sargent, who was, of course, historically a professional casino regulator, and more recently another regulator to fill a vacancy which emerged on the GWC recently. The chair and deputy chair and CCO, the deputy chair also being a ministerial appointment, have a significant influence obviously on the agenda, the materials and the business of the GWC, simply because the department, as Ms Seward addressed earlier, is responsible for the preparation of those materials and has the resources, and the only body which does have the resources, to undertake those administrative and policy roles on behalf of the GWC. But the GWC is the decision maker, and it's the decision maker on the materials which are before it in addressing a wide range of gambling issues. And I say a wide range because when one looks at the range of duties which are expressed on the face of Section 7 of the Gaming and Wagering Commission Act, the GWC has responsibility not only for casinos but also for community gaming. And we will say there that the GWC regards casino gaming and community gaming as a continuum of regulatory activity which are partially reinforcing. That is, the regulation of community gaming reinforces the monopoly enjoyed by the casino and supports and protects the revenue base that's associated with that. But also racing, gaming and wagering and lotteries. The duties are mixed and multiple. They include policy issues, oversight issues, compliance issues, including decision-making in relation to non-compliance with licences, and they are therefore both regulatory, policy, administrative, and to a degree adjudicative. It's a body which has had to conduct itself, and in its submission does conduct itself professionally, but within the constraints that it faces, both from its relationship with the department and its inherent dependence on the department, and one very real constraint, and that is its part-time and essentially voluntary nature, the very limited remuneration which is received by members of the GWC, a mere fraction of that paid to members of peer regulators, which in itself just hardly incentivises members to commit vast amounts of time other than out of a sense of public service. That sense of public service was evident in some of the evidence given before you. The GWC overall is constrained by a finite resource base and a finite revenue base. And you may have considered in the course of your deliberations subsection 2 of section 7 of the GWC Act, which identifies effectively that the Commission is to live within its means. And those means, so far as concerns casino gaming, are principally revenues derived from the casino tax. That casino tax is payable by virtue of the state agreement. The state agreement sets out an agreed basis between the state and the casino licensee for monies which are to be paid for the purpose of the regulatory function, although in GWC's contention they are not hypothecated to the casino regulatory function, but form part of its general funds. And those are limited. And they are limited because of the nature of the formula which is contained in the state agreement, which has not been revisited for very many years. You will have recalled there has been some evidence, it hasn't been greatly explored, about the possibility of the revenues of the GWC being enhanced. That could only be by appropriation, and that could only be by appropriation in a government environment which has for many years been constrained in relation to the increment of departmental funding. The very purpose of the 2017 machinery of government changes which resulted in the formation of the present department was cost saving, not the objective of increasing available funds for bodies such as the GWC. So the GWC has operated for much of its life, and certainly for the last many years, in a resource-constrained environment. Having said that, in recent times resources have been made available and there's been considerable improvements in processes I indicated. The GWC would say those have to date been principally improvements in the processes by which the department supports the GWC. What now will matter in the future is the policy which is supported, the policy development which is supported by those processes, and the implementation of that policy development into the future. And that policy development will undoubtedly, of course, be shaped by the report of this Royal Commission. Can I then turn to the inquiry and first the suitability question? Terms of reference part A fundamentally directed to questions as to the suitability of individuals and entities associated with Crown Perth, and what the conduct over a very extended period of time may demonstrate about the present and prospective suitability of Crown Perth, the Perth Casino licensee, and of its close associates to be involved in the conduct of the casino licence. And I note on the CPH party's comments about its status as a close associate at the present time. We regard those as matters for you. The question of suitability, so far as GWC is concerned, is not primarily directed to the finding of fault for the purpose of punishment, although contraventions of the casino legislation and state agreement which are exposed in the course of the inquiry and which have that consequence, which may have been exposed, may lead to action at some stage. Rather, the purpose is protective of for the future, to determine whether Crown Perth should continue to hold the licence or should be regulated differently in the future to achieve the purposes of the regulatory regime, and whether permitted close associates or casino key employees should continue to hold that status. For the most part, GWC does not make submissions in relation to the findings should make as to the suitability of particular entities or persons with respect to Part A of the terms of reference, because those are questions A, posed by the terms of reference specifically, but B, ultimately questions which GWC itself may have to confront, or a successor body to GWC, depending upon your report, in providing advice to the Minister, including potentially advice under Section 21, capital A, sub 4 or sub 5 of the Casino Control Act, if acting under the existing statutory regime, or for government or another successor regulator, depending upon the regime in the future, to address. And it's inappropriate for GWC to address specific suitability questions in that regard. One suggestion which GWC has made in its submissions, which has drawn particular ire, however, is the suggestion that should this Royal Commission ultimately recommend that the casino licence be cancelled or suspended, and that is a recommendation for ministerial action under section 21 capital B, effectively, of the Casino Control Act, as a result of properly made findings, well-founded, in relation to the conduct of persons or entities, then there is at least the option which should be entertained for legislative change, and it is in our submission a given that legislative change will be a result of this Royal Commission, to create the potential for the recommendation and findings that you might make to be effected without the GWC needing to take further inquiry action. Now, to put that in context, you will recall we have submitted in opening and elaborated our written submissions that in February of last year, the GWC resolved to recommend to its minister that an inquiry be undertaken under section 21 capital A subsection 5 in relation to matters the subject of the Bergen, what was then the Bergen inquiry and later became the expanded into the Melbourne Royal Commission, in terms which are in a less elaborate form but otherwise substantively the same as the terms of reference of this Royal Commission. And insofar as that inquiry is in both parts A and part B, and insofar as those matters go to part A, the evident purpose of that is to frame the possibility of a report to the Minister under section 21 capital A subsection 5, which would then lead, or can't say would lead, would then commence a process by which the Minister could take action under section 21 capital B. It is a consequence of the fact that this inquiry has been constituted as a Royal Commission that there is no longer a direct nexus between the chain of inquiry which might be initiated under the Casino Control Act and the consequence of ministerial decision. It is, in our submission, open for this Royal Commission under term of reference 7 and term of reference 11, that is as a matter incidental to the suitability inquiry and as an enhancement to the regulatory regime, to effectively replicate the consequence of this inquiry having been constituted under the Casino Control Act as the GWC originally advocated. That is the approach which was taken in Victoria in the amending legislation which followed the report of the Victorian Royal Commission, although interestingly it was not actually a recommendation of Commissioner Finkelstein in that Royal Commission. But section 20 subsection 12 of the Victorian legislation as it now appears as a result of the amending legislation passed late last year effectively allows direct reliance upon findings for the purpose of taking regulatory action. Of course, that does raise then the question as to the approach to the findings if they were to have. Ms Seward identified that all parties had effectively urged a singular and appropriate caution in making findings reflecting upon individuals, both in the application of an appropriate standard, the Brigginshaw standard, and I think the CPH parties have reflected Commissioner Owen's approach in the HH Royal Commission in that regard in their submissions. But also in relation to the number of findings and the number of individuals and entities that might be the subject of findings. GWC endorses that approach. It endorses the Brigginshaw approach because of the importance that there be rigour and a high degree of, with due respect, integrity in the findings. That is, that you have reached a finding in relation to an individual or entity after a high degree of confidence that that finding is appropriate and right. But also because GWC as a regulator is concerned, perhaps slightly selfishly, to have to deal with the minimum number of findings, that is to operate on what might be colloquially called the 80-20 rule. Let's take the findings that matter and are going to affect the regulatory environment in the future And perhaps if there are findings which could be made but are not central to the regulatory exercise, they may not be necessary to be made. Crown has opposed that. I think CPH has opposed that. The ground of opposition might be not one of principle, but one that recognises that, as the Crown submissions do, there will be limited or no grounds for review were that approach adopted. I'll say nothing more in relation to the suitability question. Our written submissions say some things about the suitability test in response to the suitability discussion paper, but we rest upon those. The second part of the terms of reference, Part B, deal with the effectiveness question. That is the effectiveness of the relationship between GWC and the department. There are, in our submission, 3 stages of inquiry. The first, an understanding of the statutory regime, its purpose and the respective roles allocated to or undertaken by the GWC and the department under that regime, and Ms Seward has taken you through those. And because the GWC and the department do not operate in a vacuum, the application of certain other statutory frameworks to the GWC and the department, and that includes the Public Sector Management Act and the Financial Management Act, as they may impact upon the activities of GWC and the department. That is mainly an exercise in statutory construction, and that construction may identify deficiencies in the statutory regime, and it may identify deficiencies in the understanding of the statutory regime by those engaged in the undertaking of it. The second stage involves an assessment of the department and the GWC and their performance of duties and obligations under that regime. You may identify instances where that performance falls short of expectations. Those expectations may be framed directly by the statute as a result of the exercise of statutory construction, or they might be circumstances which arise because of other extrinsic considerations. They could be deficits of resources, they could be deficits of personnel. They may not necessarily be due to a lack of diligence on behalf of the GWC or the department. An assessment of the GWC or department's performance must fairly be made in the light of the policy imperatives within the statutory regime and the policy settings of government from time to time in relation to gambling regulation, as they were understood by the department and the GWC from time to time. And as a key example in relation to that, this Commissioner spent a considerable amount of time upon questions of harm minimisation. Harm minimisation is but one objective of, I withdraw that, it's not even an objective. A consideration of issues of harm minimisation is one duty of multiple duties which fall upon the GWC under Section 7. The Commissioner has heard evidence that harm minimisation was an important consideration for the GWC in its deliberations. It personally mattered to a number of GWC members, and they brought personal perspectives out of their life experiences in relation to harm minimisation to the table, as it were, in considering those issues. But any body charged with performing multiple duties will sometimes find those duties pull you in different directions. And there are other obligations which arise under Section 7 and out of the macro policy settings of government. Some of those are evident in the state agreement. The state agreement has as one of its objectives the promotion of tourism. It has as another of its objectives the raising of money for the state. It is quite possible to eliminate any prospect of harm through the casino. But in doing so, it is quite possible that we'll also eliminate any revenue for the state out of the operations of the casino. Those are policy imperatives which may be in tension. It is perfectly open for members of the GWC to regulate the casino out of business. That has been a consideration which they have had in the forefront of their mind throughout their regulatory endeavours. There is the question of the known or perceived functions of other agencies of government, both state and federal, concerned in matters relating to the operation of casinos. For example, the perceived, and I emphasise in this regard, so far as the GWC is concerned, the word perceived, involvement of AUSTRAC and Australian Border Force up until at least 2017 in the case of the department, and later in the case of the GWC in relation to the regulation of the propriety of junket participants is one example. The involvement of VCGLR in the periodic review of Crown as part of the group holding the casino licence in comparable circumstance is another consideration which bore upon the GWC's work, and you've heard evidence from that from GWC members. Practical constraints of funding, technical and human resources within which the GWC and the department operated are realities. And we've cited in the submission some metrics in relation to the disparity in those from peer regulators. Now that goes to the question which many submissions have picked up, and Ms Seward again alluded to, that there is a risk in approaching any inquiry of this nature with hindsight bias. We do not elevate that in any way to the level which appears in the Crown or CPH submissions. A function of a PCRC, under its terms of reference, is to engage in an evaluation of historic conduct. Necessarily, that involves judging the past by reference to what is now known. But in determining what should have been known and should have been done in the past by what is now known, questions in relation to policy, functions and resources remain relevant to understand properly the decision-making process which was engaged in, and to understand the propriety and robustness of that decision-making process. That is not to say that a finding could not, should not be made, that things could be done better. But the path from what was done to what could be done better does not mean necessarily that there was error or fault in what was done. It simply means that with what we now know, other things could be done if other parameters are properly adjusted. The third and final stage of the effectiveness inquiry involves the recommended enhancements to the statutory regime for the future in accordance with TOR 11. This involves policy formulation and is constrained by the terms of reference that the recommendation must be for an increase or improvement in the statutory regime. PCRC is not given a tabula rasa in relation to the reform of the regulatory regime, but it has significant scope to recommend improvements. Common to both issues is the importance of caution and precision. I've addressed that in relation to the finding in relation to individuals and entities that might be made. What I want to be clear and to ensure that all understand is that there should be no misunderstanding of GWC's closing submissions in relation to the urging of caution and precision. GWC urges no sympathy for Crown or any past or present Crown officer, nor indeed, regrettably, to the extent that it may be necessary, and only if it's necessary, departmental officers or former members of the Commission. But GWC has a broad regulatory remit and still, at the moment, limited resources. Consequently, GWC needs any findings by this Commission upon which it might be able to act to be precise, well supported and not susceptible to challenge upon the basis of undisclosed information. If the GWC needs to rely upon that finding for its own purposes, it also needs to deal with a manageable number of findings that require action. A level of discrimination is useful, if not essential. In a number of instances, particularly in relation to issues of communication with the GWC, findings are urged by the GWC, and that's not to say specific findings are urged, but rather a finding that there is or is not a fault, if that finding can properly be made. And as I recall, I think there are 6 or so particularised instances in our closing submission of interactions between the GWC and Crown in relation to areas of communication, where GWC urges this Commission to reach a landing, as it were, in relation to those findings. Those are important matters to set the relationship between GWC and Crown for the future, and they may inform recommendations that may be made for regulatory reform. There are a number of other matters where, from the closing observations, there are matters open to find, which we want to make some brief observations about. First of those is harm minimisation and EGMs. GWC agrees that it has a duty, amongst other duties, to formulate and implement policies for the scrutiny, control and regulation of gaming and wagering, taking into account the need to minimise harm caused by gambling. That is its obligation under 1, I think it might be EA or E1 of the provisions of Section 7, subsection 1 of its Act. It's one of a number of duties expressed in the regime. It requires the GWC to take into account the diverse requirements and interests of the community as a whole. Accordingly, in our respectful submission, this Royal Commission should not consider the duty to minimise gambling-related harm paramount among the other regulatory objectives of the framework. It may be that after having heard the evidence that is before the Royal Commission and assimilated those findings, you wish to make that recommendation that it should be a paramount consideration in the future. And if so, and our regulatory discussion paper addresses this, there are means by which objectives can be framed in future legislation and a hierarchy of importance for those objectives shaped, which would accommodate that policy objective. But that is explicitly then a recommendation for policy change. GWC's submission, it can't be disputed that it did in fact place considerable emphasis upon a duty to minimise gambling-related harm when formulating and implementing policies. That is the undisputed written and testimonial evidence of the GWC before this Royal Commission. The closing observations make a number of contentions with respect to the GWC and its role in minimising gambling-related harm, including that its effectiveness in regulating and overseeing harm minimisation in respect of the operations of the Perth Casino may have been compromised by the lack of current information, particularly research and statistics, and that it did not sufficiently take into account gambling-related harm when formulating and implementing policies. Neither of those contentions is supported by the GWC. With respect to the lack of current information, GWC accepts that it would have been assisted from time to time by independent current information as to the prevalence and nature of gambling-related harm. And initiatives are underway, as we understand it, to enhance the available information. However, GWC was provided with research and current national statistics compiled by other state governments and respected gambling institutions through the department. It was, in more recent times, it's been provided at its request with monthly RSG statistics from Crown Perth, from which trends could be discerned and probed. But importantly, in terms of actual outcomes, the premise upon which the GWC was operating, based on prior Productivity Commission research and periodic national information, is wholly consistent with what appears from the latest research from Professor Rockloff. That is, despite a higher proportion of Western Australians actually gambling than the rest of Australia, the level of gambling problems in Western Australia is considerably lower across the board, and in particular in relation to what Professor Rockloff's research categorised as being problem gamblers. And that is just so despite Western Australian gamblers being twice as likely to participate in casino gaming as those in the rest of Australia. There is an obvious reason for that. Western Australian gamblers participate in casino gaming because it is the only place that they can gamble on table games and EGMs. And the rest, in the east coast of Australia, EGMs are disseminated far and wide in the community and present a far greater regulatory challenge than they do in relation to a single site. and manifest considerably more harm through EGMs and keynote participation in East Coast in diverse and distributed venues than in Western Australia. WA's single site regulatory regime works on the data. No one to date, so far as we can ascertain, has clearly articulated how access to the postulated information which is now available through Professor Rockloff's work in any prior period would have affected GWC decision making, as the information now available is in fact consistent with the information that was then available, even if it was dated. So the premise is that if the research had been undertaken, GWC would have found out what it now knows from Professor Rockloff's research, which is what it believed was the case in any event. In relation to EGMs, they carry a risk of harm as much as elsewhere to those who play them in Western Australia. The finding from Professor Rockloff's research tends to support the need to revisit the functional definition of an EGM, and we've addressed this in our submissions on the discussion paper on EGMs, with an emphasis on harm minimisation features. But in GWC's contention, any features or practices recommended in relation to EGMs should rest on a robust theoretical, if not empirical, foundation, and cannot proceed from the foundational proposition that a loss in and of itself is harm. Indeed, I think Professor Rockloff gave a slightly colourful piece of evidence which said the risk of losing is the fun. And the risk of losing has to be translated into actuality at some stage. Most of the measures commented upon at Part 4.2 of Professor Rockloff's report do not obviously meet the requirement for theoretical or empirical robustness. Now, with respect to the sufficient consideration of harm minimisation when making decisions, in the absence of requirements in the statutory regime to put harm minimisation considerations above all else, the GWC is entrusted to balance the potentially competing considerations, in this case by its duties in making decisions. GWC says that it undertook that evaluative exercise from time to time in good faith and based upon the information before it. Another decision maker, commissioners, that means you, might make a different decision, but it does not appear to be capable of being disputed that the GWC members did in fact take into account gambling-related harm when formulating and implementing decisions in relation to gambling in Western Australia and gambling at the casino in particular. Now that's what was. Going forward, GWC's view is there should be clarity in the purpose of the regulatory framework by the inclusion of an objects clause or a principles clause or both, and that in that new clause a requirement to minimise harm caused to people or any group of people due to gambling should be a primary objective. Further, GWC is in favour of and advocates for a statutory obligation imposed upon the casino licensee to develop a gaming harm minimisation program at the Perth Casino and a responsible service of gaming initiatives. These are already underway within GWC, the department, and in conjunction with the Problem Gambling Support Services Committee. And I'll just interpose there to reinforce what Ms Seward said in answer to questions from Commissioner Jenkins. It is also the position of the GWC that the PGSSC is not and has never been a subcommittee of the GWC. It is not constituted as such. It is a body which has been facilitated by the GWC, and the GWC through the department provides both, A, provides some funding, and B, provides, I think, a special purpose account for the administration of funding in relation to PGSSC. But it was an initiative of Mr Sargent, that was his evidence, to fill a need which the legislation at the time did not accommodate.
Sorry for interrupting, but then why is it included in the GWC's annual reports?
My understanding, and I'm sure Commissioner Murphy can explain this better than I can, is that the money once funds are under administration, they have to appear somewhere, and that somewhere is the GWC.
Well, the annual reports certainly don't make it clear that that's why the information is in the GWC's annual reports. It's presented, is it not, as if it is a committee by which the GWC assists in problem gambling, or the management of problem gambling in Western Australia.
It does appear in the annual reports in that way.
You're saying that's wrong?
I fear it may be. That may be one of the errors that you may discern and report upon. I think Commissioner Murphy.
Thank you.
Look,
Sorry.
I certainly observe a disconnect between the view that it's not a subcommittee of the GWC, and of course in financial terms, I mean the accounts of the PGSSC are part of the accounts of the GWC. So if that's the case, then any payments authorised by the PGSSC would need to be authorised by the GWC.
It is one of the areas for improvement in the regime, and you may well recommend that the PGSSC should become a subcommittee or should be absorbed in some way into the regulatory regime. PwC has no objections to the regularisation of that. It simply observes that the history does not seem to support the notion that it is in fact a subcommittee. As a result of that, there are some disconnects in the reporting and management of the finances of that body. Generally, the GWC favours and advocates for a more principles-based approach to harm minimisation around an as low as reasonably practicable cost, rather than a prescriptive and rules-based approach. This view is predicated on the fact that not all gambling expenditure is harmful and not all gambling activities cause harm. In our respectful submission, no evidence has been led that suggests that such a conclusion should be drawn. But some gaming activities do cause harm to some people, and such harm should be reduced as far as reasonably practicable. The calibration of that notion of reasonable practicability is a question of considerable and the GWC does not consider that the evidence which has been received by this Commission to date allows a finding in relation to what the level of a threshold of harm should be. And I'll turn in a moment to a question about thresholds. Some prescriptive rules, properly founded, may be appropriate for ease of administration and auditing in the performance of regulatory functions. They may also be appropriate as interim measures pending the development of more theoretically or empirically robust measures. Crown endorses GWC's approach, as we understand, we read their submissions, to risk which has Crown principally responsible for managing and mitigating its own risk. But as we again read their submission, seeks to avoid GWC scrutinising and auditing that risk management. The GWC considers that it's necessary that it satisfy itself that Crown has apparently suitable risk management mechanisms in place as an integer of suitability. The directions in casino manuals at the moment are aspects of risk management scrutinised by GWC. It's apparent they need wholesale revision in the light of Crown's improvement program. And because of the complexity of those systems, GWC considers it likely that it will need external assistance in the assessment and auditing of compliance in the future. Again, as an incident of assessing ongoing suitability.
Sorry, Mr. Evans, you're now talking about risk management generally, not harm minimisation.
Sorry, my apologies. Risk management more generally, although harm is obviously a significant component of that. It's apparent in GWC's submission that audit was not previously adequately successful in attaining that objective. Crown raises in opposition that there will be a duplication of audit functions if a separate GWC audit of risk management is required. There are a couple of answers to that. One would be remarkably brief, but there is potential for a harmonisation of external audit to function both for the purposes of Crown and for the purposes of the GWC. That would be a matter which could be developed. But given that the objective is to audit compliance by Crown with its obligations, the GWC considers that reliance upon internal audit is an insufficient safeguard going into the future. Can I then turn to remediation? Because it features very large in Crown submissions for obvious reasons, and it has featured significantly in the stage 4 evidence before the Royal Commission. Crown has addressed and adopted GWC's contentions that certain criminal infiltration risks have been mitigated at the present, partly through measures adopted by Crown and partly by circumstance. Again, GWC wishes to caution that should not be misinterpreted on its behalf. You have heard considerable evidence about the risk mitigation measures which have been adopted in relation to money laundering issues using certain typologies and in particular certain bank accounts in the latter part of this inquiry, but also in the last few years. Those last few years, 2017 onwards in particular, coincide of course with the collapse of Chinese gambling tourism for reasons which are wholly extrinsic to the regulatory exercise, and more lately still, the closure of borders within Australia. GWC is concerned that the mitigation may not persist. That is, the lessons of the past may be forgotten in the future, and systems put in place, great confidence, may over time weaken and wane. That may be because of, at worst, conscious internal decision making, but simply because, as in the case of the Department and the GWC, all enterprises and entities are strained for resources, and sometimes resources diminish over time. One of the important considerations for GWC in the findings that you may make is the conclusions that the PCRC reaches on an affirmative level of satisfaction that the risks have been, in fact, by the mitigation measures, or will be mitigated in a relatively short time frame, and that mechanisms are available which will ensure the validation of that mitigation in the future, to the extent it hasn't been undertaken, is not yet complete, or that to the extent it's dependent upon a current absence of overseas gambling participants due to market changes and extraordinary circumstances. GWC is also concerned that historic risks are not the only risks addressed in regulatory reform. At the very least, recommendations should focus upon frameworks that can be employed by a regulator in conjunction with government to the extent that legislative instruments are necessary, which are adaptable to changing circumstances, including perceived or actual levels of risk over time. In preference, the recommendation of a form of regulation focused on one specific risk, even if that is a serious risk. There is no guarantee that yesterday's problems will be repeated in precisely the same form. There is almost a guarantee that new problems will emerge in the future, and the regulatory regime must respond both to what has happened and what may happen. For the full range of risks exposed by gambling generally and casino gambling, Crown suggests that GWC is off the mark in inviting you to consider whether Crown's culture is so flawed to be irredeemable. That submission responds to a submission by GWC in relation to the assessment of individuals, which concluded with the suggestion that the Royal Commission should not fall into the acceptance of what amounted to a Nuremberg offence by individuals if they were engaged in conduct which was plainly wrong, and then moved to the difficulty of assessing remediation of entities. Crown's submissions on future suitability are predicated on changes to leadership, management and processes, producing sustainable change in areas where Crown's behaviour in the past may be found to have demonstrated failings. In responding to the suitability discussion paper, GWC provided an extended explanation of the traditional and broader approach to attributing responsibility for acts and omissions to corporations, and whether that was applicable to the consideration of past conduct of Crown in answering the suitability question. Our approach was to say that while it agreed with the traditional approach in assessing past conduct focusing on directors, officers and employees, and the broader approach, a broader approach is available which concentrates on system, strategy, structure and culture that is not a point-in-time assessment. If circumstances of misconduct are found to have occurred over an extended period of time during which leadership has changed, with the result that systems, strategies, structures and cultures were either allowed to stay in place or amended in line with the views of changing leadership, it may be open to you in evaluating the evidence to consider whether Crown's demonstrated pattern of non-compliance, if that is found, with expected norms manifests deeper structural and cultural flaws, the remediation of which is not responsive to changes in one or even a number of individuals or internal structures. That is a difficult exercise in evaluation, but one which in our contention is at least necessary for you to engage with in the final report. Against that, the understanding of our reply submissions should be assessed. GWC is not saying that Crown's culture is so flawed as to be irredeemable. Even if it was inviting such a determination upon Crown, the more correct but still incorrect formulation would be that Crown's systems, strategies, structures and cultures were irredeemable. What we say is that it is important for this Commission to engage with the reform program as to whether it offers the real prospect with a high level of confidence that both changes in leadership and changes in systems will produce consistent, compliant behaviour across the organisation, both imminently and in the longer term. Because we have to regulate the casino in the longer term. There are other differences in approach between GWC and other interested parties. There is some attention on junkets and international commission business, and the history of the engagement with junkets and ICB has understandably occupied much of your time and a considerable part of the time of the Bergen and Finkelstein inquiries, in particular given the susceptibility of junket and ICB business to money laundering and criminal infiltration. Now, we would contend it's fairly obvious from the evidence that we have been let down in relation to junkets on a number of levels. I don't propose to repeat our submissions in that regard. But it is the case that 20 years ago, the scrutiny of junket operators at a meaningful level had fallen into a level of disrepair, and formally was dispensed with some 10 years ago, although in a way which raises some issues as to the approach adopted. From that time, effectively, junkets were not scrutinised in any way. The residual requirement to provide information as a result of provisions of the Casino Manual Operations were, of course, removed in April of 2017, and there are issues in relation to that process upon which you might make findings. Now, the Department's views, which informed actions and communications with the GWC in relation to those actions, those regulatory reforms up to April 2017, are understandable as mistaken but honestly held beliefs, at least until the time of the AUSTRAC's publication of its 2017 engagement with gambling regulators. That publication identified that AUSTRAC and the Australian Border Force were not in fact performing the probity functions that the Department had assumed that they were, and was a clear indication that the Department's assumptions regarding regulatory reach was unsound and required to be revisited. It must be said that the same could be said of many of the other regulators around Australia as reported in that publication. Looking forward, there is a certain equivocation on the evidence from a number of Crown officers as to what junket and ICB business might be in the future. At the moment, there is no junket or ICB business at the casino for two reasons. One of them is wholly practical. There are no foreigners entering the country. The second is there is a direction in place from the GWC which precludes such business being undertaken at the casino. The issue which arises from a policy setting is that the state agreement, of course, contemplates the such business. A section of the state agreement dealt with the taxation of such business. And it's apparent from the more recent evidence from Crown that some form of international commission business, that is, business involving international gambling participants, would, with appropriate regulatory oversight, be endorsed in the future by Crown. That's as we understand their evidence. And it would be consistent with the state agreement. It would be consistent with significant parts of the infrastructure at the Crown complex, which were developed for that purpose. And in our respectful submission, it is not inherently risky that foreign gambling at the casino, I'll rephrase that. There are risks in relation to foreign gambling at the casino. Those risks inhere to the way in which money is handled by foreign gamblers in particular, and historically by junkets. That must not be permitted to be repeated. The opaqueness of the financial transactions within junkets are a significant criminal infiltration risk. That has been identified clearly in this and the prior two inquiries. That does not mean that foreign gambling participants must be forever barred from the Perth casino, either on an individual basis or on an organised basis. What must be regulated is any aspect of that involvement by foreign gamblers in casino activities which creates a material risk of the misuse of the gambling facilities of the casino for a criminal purpose. As a regulator, considering the state agreement and considering a broad set of interests, GWC does not consider that a form of foreign gambling tourism or foreign gambling should be forever prescribed. What is necessary, however, is an appropriate regulatory construct to facilitate that at minimum risk. What that does not mean, in our respectful submission, is that the risk of approval and supervision should be wholly transferred to an external party. Crown has accepted in its risk management submissions that if Crown owns the risk, it should manage the risk. And our regulatory and governance submissions make plain that in our contention, Crown must always have the principal responsibility for determining who it deals with and should bear the consequences of errors in that decision-making process. An attempt to move the risk in relation to the approval of foreign gamblers to a regulatory body creates a form of moral hazard. Crown gets to transfer the risk away from the regulator and then argue it's the regulator's fault if, for some reason, criminal infiltration occurs. That should not be the regulatory construct. GWC should regulate those issues in the same way it regulates casino licensees and casino employees, but it needs assistance. Foreign gamblers face particular difficulties in relation to approval. Those have been recognised. What we now know from evidence in this commission is that the sources of intelligence which are now available to Western Australian Police are considerably better than they were 10 and 20 years ago, at the time when the approval process for foreign junket operators fell into practical disrepair. But it is no use Western Australian Police having those resources and those sources of intelligence unless they are deployed in aid of the regulatory regime. GWC maintains the position that it is not a law enforcement agency and it is not desirable that it becomes one. And part of any regulatory reform needs to be a recognition of the respective roles and responsibilities of the various agencies that are engaged in law enforcement and the creation of proper and appropriate interfaces between those agencies and the GWC. There is some indication of nascent development in that area in the evidence, but there is much yet to be done. Commissioners, unless I can assist you further, and I'm sure the questions were being noted down as I spoke, I have no further submissions on behalf of the GWC.
Thank you. Got some questions?
Only one, Mr Evans. You've said the GWC operated in a resource-constrained environment. I accept that. Does that create an opportunity or an obligation to go to government to seek additional resources?
It does at an abstract level, Commissioner, recognising that to do so practically GWC goes through the department, and there was some evidence about that from the department CFO, from former directors general, and also from GWC members about that idea being floated. That's not detailed evidence, but suffice to say that it might be that that possibility would have been entertained, but looking at Section 7, subsection 2 of the GWC Act, one would not say warmly entertained. But in crisis, there is opportunity, as the Chinese proverb goes, and we currently have a crisis, so there's opportunity.
Thank you.
Mr Evans, first issue I'd like to deal with is the composition of the GWC. So one of the new members you spoke about is Mr Sarkwi. Is that how
It's as good a guess. I only refer to him by his first name, Commissioner. So,
can I just understand, is he resident in Western Australia?
no, he is a permanent resident of Queensland and is the equivalent to the chief executive of the gambling regulator in Queensland. I can't recall his precise title, but he's a.
Is he retired from that position?
No, my understanding is he's a full-time public servant in Queensland.
And he's also a member of the he's been appointed as a member of the GWC.
I might, yes, I understand that is correct. He is. So it's an additional duty for him. And I understand there's been another appointment of another regulatory officer.
I was going to come to that person, so
Yes.
let me deal just with Mr Sarkwi. So has it been considered whether there's any conflict for Mr Sarkwi between those two roles?
I have no idea because, with respect, the GWC was not consulted in relation to his appointment. It was an appointment by the Minister.
Moving on to the second person. Who is that?
I don't know whether there's been a formal announcement. Again, Ms Seward may. Yeah, no, Ms Seward doesn't know whether there's been a formal announcement of it. I can say it's an experienced regulatory officer who currently has a position with an interstate casino regulator.
Thank you.
And I actually cannot recall their name.
You spoke about, moving on to another topic, you spoke about policy development that was going on. And I'd just like you to elaborate on what the GWC sees as the differing roles and responsibilities in terms of the policy development for casino regulation between itself and the department.
Can I put it in these terms, Commissioner? The resources for the undertaking of policy development rest with the department. It has been the case that for quite a long time, policy initiatives were principally driven by the department, which had a broad purview of government and policy within government. More recently, the GWC has taken, the current commissioners have taken a material interest in specific policy development as issues have been identified to them in a way that perhaps they did not engage with in previous years. Now, there are obviously, through the Bergen inquiry, through the Finkelstein Commission and through this commission, there are areas of policy development which have been identified. Harm minimisation is an obvious one and is an area in which work is currently being undertaken, where GWC is now actively engaged with recruiting the department to support it in policy formulation. That's as a result of the strategic planning exercise, which Ms Seward referred to, and which of course you had evidence of from GWC members that they've been pushing for a little bit of time.
So I'm just wondering how going forward, if the current regulatory framework remained as it was, who decides and directs policy development for casino regulation in Western Australia? Is it the department, or is it GWC, or is it an ad hoc mixture of both?
In the current regulatory regime, and it is one of its potential weaknesses, the duty, of course, rests upon the GWC to engage in policy development. That's the duty under Section 7. The practicality of the performance of that duty is that the policy resources reside within the department. And it's fair to say that, except for the most recent appointments and Mr Sargent's tenure, and of course the role of Mr Connolly as CCO and Deputy Director General, the policy capability in the specific gambling area has rested with essentially departmental officers. The members of the GWC historically have not been, or the ordinary members have not been policy people. So there is a practical dependence for policy generation upon the department. It may be that from time to time something is exposed to the GWC which causes it to think about, we need more definition in policy around here, which then may drive them to ask the department to do some work on policy. That, and you will have seen, or your council assisting will have seen, in the papers over time, reasonably material policy papers coming forward in the agenda materials for the GWC, at least some of which are driven from questions risen from the GWC itself. But the policy assets and competence and the professional casino and gambling management skills have rested within the department. Now that of course drives, if I might step that out one stage, issues in relation to the potential regulatory reform models, and whether, if you were disposed to recommend reform to the regulatory regime, you would do so on a basis which included a standalone policy competence for the regulatory body. And the model which the GWC has put forward as its recommended model in its regulatory response to the discussion paper is one which would have a policy function organic to the GWC and responsive to the GWC, a policy and research function, in fact, to enable the GWC to initiate and control policy formulation autonomously.
Thank you, Mr Evans. You spoke of competing regulatory objectives, acknowledging that there are no actual objectives in the Act. You said that GWC had in the forefront of its mind, either individuals, I suppose, or collectively, a desire not to regulate the casino out of business. Is that, am I right in summarising your comment in that respect?
That would be to slightly flip the comment, if I might say, Commissioner. The intent was certainly to say that the GWC has been conscious that it has the capacity to regulate the casino out of business. That is, the power to direct under Section 24, I think it is, of the Casino Control Act, the casino in relation to matters pertaining to the playing of games and associated matters could be used in a way which would effectively render the casino unviable. Now, obviously, it would not achieve the other objectives of the GWC and the regulatory regime to do that. But when considering any particular regulatory initiative, one of the things that GWC has to consider is what is the impact of this upon the casino. It's a point that we make, in fact, in relation to the recommendations that you may make, that one has to assess them holistically and consider what their impact is going to be upon the objectives of the regulatory regime, because you could recommend...
That's what I'm trying to get at, really, is, so are you effectively saying that what you've just said, that it is something GWC, the financial impact of a regulatory step on the finances of the casino is something that the GWC bears in mind, at the very least, when it's regulating the casino?
Can I put that one step back from that point? Because Ms Hodson-Thomas, I think, for example, gave evidence that she didn't care about what the regulatory impacts of a particular decision were. But the GWC has to bear in mind that the state has decided there will be a commercial casino. And therefore its overall approach to regulation in the broad has to be that overall it can't regulate the casino out of existence.
But does that mean that's a kind of different concept to whether it bears in mind, and it's appropriate for it to bear in mind, the financial impact of a regulatory step?
The evidence would not support the conclusion, I don't think, that that has been a specific consideration in relation to any decision. It has been a factor which has been urged upon the GWC, because you'll recall, for example, in relation to the EGM changes, which were sought in 2019, there were overtly financial considerations in support of that.
So that's really where I was going
Yes.
to. Trying to tease out from Mr. Evans what GWC's position is under the current regulatory regime as to whether that kind of submission, I agree with you, that the submission in respect of the change of speed and other changes to the EGMs had as one of its justifications this is from Crown, the financial benefit to Crown of those changes.
Yes.
And I'm trying to find out from you, are you saying that that is something that the GWC then did and should bear in mind when it makes its decisions under the current regulatory regime, or are you saying something different?
My understanding of the evidence in relation to that decision was, to the extent it explored that question, was that it did not support a conclusion that the financial outcomes were in fact a component of the GWC's ultimate decision. Again, the GWC's position, as I would apprehend it, is that while the financial impact of a particular decision might not influence the outcome of that particular decision, it is the case that they are regulating a commercial casino, and it's a casino which must be allowed to operate commercially. And that, of course, has an effect upon what I call the general approach to the regulatory task, because one is always balancing competing considerations. But I'm not sure the evidence in these proceedings go to the level of granularity to say that it affected any particular decision.
Seem to be having a bit of a bet each way, Mr. Evans. Can I, in respect of, say, the application with respect to EGMs is but one example. It's true, is it not, that the GWC never challenged Crown's assertions about the financial effect of a regulatory step on it?
That is correct, as I understand the evidence.
It never initiated its own independent assessment of the financial effect.
It relied upon the agenda papers.
Yep.
In that regard. And I do think there was I have a recollection that it's a Mr. Lee point that they were criticised for not recalling an inconsistent point from an agenda pack some months previously, 600 pages into a 1,200 page agenda pack in the process of that decision making. But any criticisms?
I'll try not to get diverted from my task by that comment, Mr. Evans. But going then to the objective regulatory framework, putting aside what evidence the GWC members gave as to whether they did take it into account or didn't, are you saying, on behalf of the GWC, that the impact of a regulatory step on the finances of the casino is a relevant matter under the current regulatory framework for the GWC to take into account when it makes its decisions in respect of casino regulation?
Ultimately, yes. Because, and I say that I need to expand on that slightly, if I might. That is because the aggregate regulatory settings have to permit the operation of a commercial casino. Now, that doesn't mean that they figure prominently or at all in any particular decision, but the aggregate regulatory settings have to permit. Now, to take possibly a more straightforward example, the number of EGMs permitted on the floor of the casino at any given time has an economic dimension. They're always supported by economic submissions, and the revenue implications of an additional group of EGMs being approved is a proper consideration in the course of that approval process.
So what then does the GWC say in response to this proposition, that if that is a legitimate matter for consideration, that it was incumbent upon the GWC to obtain some independent assessment of at least the major regulatory steps it took in respect of casino regulation on the finances of the casino, either by initiating their own independent assessment or requiring Crown to obtain such an assessment?
This, to a degree, comes down to the regulatory relationship. Look, without doubt, and again, this is where we come to the benefit of hindsight, there would be a case for a significant regulatory step. And what the threshold for that is, again, is difficult to say in vacuum. For a significant regulatory step which was said to have revenue implications, to be supported by a business case, and for that business case to be auditable, if not audited, during the approval process. That might well be a regulatory improvement of process or of regulatory framework, which might be recommended or adopted by the GWC autonomously, with the benefit of the learnings from this commission.
So again, could you respond to this proposition? Could it be said that the failure of GWC to do that in the past over 30 odd plus years is a sign ultimately of their regulatory capture by Crown?
In our submission, no. Regulatory capture has in our submission has a relatively specific notion that the regulator has subordinated its decision-making process to the interests of the regulated, either consciously or through some other process. And in the US, it has a particular meaning because of the nature of the interchange between regulators and regulated. That is, most of the commissions that regulate key regulated industry in the US are on a revolving door between officers of the regulated and officers of the regulator. That is not the case in Western Australia, or indeed in Australia more generally. What it is in our submission is a recognition that the GWC has relied upon the candour and the integrity of the submissions put to it from Crown through its department in the past. And it may be that its reliance was not justified in all cases, with the benefit of hindsight.
Thank you, Mr. Evans. You may.
Perhaps I'll identify this only for transcript purposes. If you look, if Commissioner, you were to look at a good example, it's from 10 years ago, but it's a good example of a balanced regulatory paper considering these multiple issues. There's an impact assessment of the proposed increase in gaming capacity at Crown Perth, GWC .0002.0016.0077, which includes a consideration of economic factors, harm minimisation considerations, and other elements as part of what I call a balanced scorecard evaluation.
Thank you, Mr. Evans. I was going to go on to harm minimisation. You submitted that there's that the GWC's policies and decisions always had harm minimisation in mind. That might be a very poor summary of what you said, but I just want to set the area that I want to go to now. And in that respect, I want to ask you about the GWC's approach to a responsible service of gambling code of conduct. Is there any evidence as to why the GWC did not require the Crown to have a code of conduct and direct what its content should be?
As I recall, there is no evidence on that, not that I can bring to mind. Bearing in mind that it's 60 days of evidence and I've got no idea how many documents. Can I?
Well, perhaps if I stop you there and ask you the next question. How would you say that omission is consistent with a regulator who had harm minimisation at the forefront of its collective mind?
Perhaps this goes to one of the weaknesses in the regulatory regime to date, which is that it is fair to characterise the principal functions of the GWC as having been operational rather than strategic for a lengthy period of time. And there are reasons for that, and they're addressed in part in the submissions. And that if one had sat back to consider strategically harm minimisation within the policy formulation and the harm duty under Section 7, subsection 1, it might be that policy might have come forward favouring some kind of code of conduct. That was not done. Now, that doesn't mean that harm minimisation wasn't a consideration in the operational decision-making, and evidence is, I think, clear in relation to this from Commission members, some of whom, as I said in addressing, had life experience in relation to harm caused by gambling, and for whom it was a personal issue, if not a crusade. And both on the papers for the GWC, and you'll find many mentions to harm minimisation in the papers, and the paper I just took you to is an example where that was very well articulated as an express consideration. But the evidence of the members was it was something we were thinking about all the time, but at an operational level. And as a strategic tool, codes of conduct did not come forward for consideration. Now, of course, the legislative framework is different here to the East Coast, and the slightly more modern eastern states legislation, particularly New South Wales and Victoria, codes of conduct are more explicit regulatory tools which are contemplated.
Thank you for that. The next matter I wanted to ask you about was your oral submission about WA's benefit of having a single site where EGMs can be played, and that this is a successful harm minimisation tool, effectively. So I just want to understand what you're saying about that. Are you submitting that GWC can have a more relaxed attitude towards harm minimisation in respect of EGMs than in a jurisdiction with multi-site?
I think it'd be difficult to say that, Commissioner, because we have the most robust approach to EGMs. We have the highest return to player. We have the longest play times in relation to EGMs, which are considerations. No, simply that the nature of destination gambling in Western Australia. If you're going to play an electronic gaming machine, you cannot play it by walking past it on the corner of the street at a pub or a club. You have to go to Burswood to play, and that exposes you to both innate harm minimisation characteristics of those approved machines, but also the other regulatory mechanisms. Your picture is going to be taken on 2,000 cameras. You'll be able to draw limited amounts of money out of a cash machine, which must be a certain distance or must be operated electronically within the site of a casino employee if it's an SPOS machine. There are significant harm minimisation advantages, as we understand, and my understanding is that as the GWC has always understood it, from the single site regime. It's a combination of factors that reduce overall harm, and that appears to be borne out on the evidence, most particularly Professor Rockloff's most recent research.
Thank you for that clarification. Just a couple of small matters I just want to clear up. So it seems from the evidence that the Chinese staff of Crown, or also only a significant number of them, the Chinese staff and ICB staff of Crown who were arrested in the China arrests, had casino employee licences from the GWC. And is there any evidence as to why they did?
No. In fact, I'll confess that's actually news to me. It's not something I had looked at in the course of the materials to which I've been exposed.
Well, that is the conclusion. Well, that is a conclusion. I won't say it's the conclusion, but it's a conclusion from correspondence that Crown sent to the department and GWC or GWC, depending on how you want to characterise it, afterwards, which included the licence numbers of the staff and a proposition that this information was being provided under Western Australian regulations.
Which would be appropriate because it would be a contravention which required disclosure.
Can I take that? Convicted. This was after their conviction.
Yes, I'd have to take that on notice if I might, and I'll confer with Ms. Seward and her instructors and see if we can come up with a position in relation to that.
Thank you. And my final question is about the GWC not being a law enforcement agency. Acknowledging that GWC is not a criminal law enforcement agency, do you acknowledge that the GWC is a regulatory law enforcement agency? That is, it does have power to commence proceedings for breaches of the regulatory framework?
Indeed, it has the power to authorise. The Chief Casino Officer has the power to authorise GWC officers within the scope of the Casino Control Act and the GWC Act. Offences framework, and you'll see there's an extra at the back of our principal submissions which look to the glaring discrepancies that there are in that legislation in relation to the offences. Now, we accept that it is a regulatory enforcement agency. The distinction we draw between a law enforcement agency and a regulatory agency is really focus. and skill sets. Regulatory enforcement agencies recruit skill sets according to their regulatory remit. Law enforcement agencies, which can be either specialised or generic, generally have far greater investigative tools and powers, and with that, far higher standards of obligation in the exercise of those powers. But they also have in relation to the criminal conduct with which we are concerned, it's criminal conduct that is not within the regulatory regime. No part of the GWC Act or the Casino Control Act says don't money launder. That's in the criminal code. Though questions as to whether criminal infiltration has occurred, that is relevantly not the infiltration of the casino and its management personnel, but the infiltration of the gaming system, is a suitability question which goes to systems and processes. But it's one where the tool set currently employed by the regulator would be, in our submission, manifestly inadequate to handle the investigation of those tasks. It's something that should be done in conjunction with or by a law enforcement agency. Otherwise, a finite resource base gets spread over a much larger range of activities than it's designed to accommodate.
Thank you, Mr. Evans. Can I just go back to that China issue? What I was going to ask you, so you might also consider this, is that if they were licensed casino employees by the GWC, what effect does that have on GWC's obligations when those arrests took place?
So we'll look into that and come back to the Commission in writing.
Thank you.
Mr. Evans, could I ask you some questions about the structure under which the casino operates? It's still, as I sit here at the moment, not sitting easily with me, and I hope by the end of tomorrow there'll be greater clarity in my thinking. But I only want to ask you about regulatory aspects of the structure. One of the propositions that emerges from the materials is that since corporatisation, that's since 1997, it's Burswood Limited that has owned and operated the casino, Perth Casino, using the trust structure. Now, if you extend that word operate, there's an implication there that Burswood Limited is the casino operator. Is that something to which the GWC has turned its mind as to who is the casino?
I think we made some submissions in our closing submissions about that, Commissioner. I can't immediately bring them to mind, but my recollection is Burswood Nominees is the licensee, and it is the licensee that has the privilege of conducting business under the casino licence. But Burswood Resort Management actually provides all the staff, procurement, many of the facilities, and there is some disconnect in that regard. It's not an intractable problem in the sense that it is certainly possible to have a regulated entity which simply enjoys the privilege of carrying on the business, although it contracts all of the resources which are required for that purpose.
So which would be the body that the GWC is regulating?
In those circumstances, principally I would have thought Burswood Nominees as the licensee, because it's the subject of the regulatory regime. There are collateral issues in relation to Burswood Limited, of course, because probity approvals in relation to the public company or the approved company are catered for within the state agreement, and certain functions are conferred upon the GWC in relation to those probity approvals.
But not probity approvals in relation to the appointment of officers of the company.
We do undertake probity approvals at a level of generality for the approved company and for Crown Resorts Limited itself. And of course, Key Casino, under an approach which should be in place Mind you, excuse me while under a system which has been in place, I think, or a GWC policy which has been in place since about 2004, the chair and chief executive of Crown Resorts, so of the relevant parent entity from time to time, hold key casino employee licences with all the requirements under the regulations other than the requirement for fingerprinting, which was waived. And similarly, as I recall, the same is true for, it's in paragraph 391 of our submissions, resolution 290 of 2004 from the PBL takeover. There's a 3-tier approval process. All Burswood Limited directors and officers are licensed as key casino employees. Directors of the immediate parent, the chairman of the board and the chief executive officer of the ultimate parent are licensed as key casino employees. And all of the directors in the corporate structure are required to provide a completed personal particulars form and undertake a national police clearance.
Yes, one of the reasons I ask is that the direction-making power, which is a significant integral part of the regulatory process, is directed at the casino licensee.
It is.
It's Burswood Nominees Limited.
Which is not, for those directions which are directed to processes, and it's hard to think of what direction is not directed to a process. I don't think there's a difficulty with that in the sense that the processes are the processes of the licensee, even if they're carried out by personnel employed by another entity. And the liability for a failure of those processes should still properly rest with the licensee, because ultimately it's the risk is borne by the licensee that the licence may be impaired if it fails to operate in accordance with them.
So the probity approval, so you've got the situation where there is express requirement for probity approval of a person appointed who's to be appointed as a director of Burswood Resort Management Limited.
Yes.
But not either Burswood Limited, which is said to be the owner and operator of the casino, and not Burswood Nominees Limited, which is the licensee. But the way that probity applies to them is through key casino employee licence. Is that the position?
That's the position at this stage, yes.
Right. Do you have ready access to the Casino Control Act?
I do.
Just one very small point about the definition of casino key employee in section 3 of the Act.
Yes.
As the GWC turned its mind to this question, looking at paragraph A of that definition, would that apply to a person who is, say, the general manager or in a senior management function of a centralised service, but has no other, that provides centralised services to the Burswood Casino, the Perth Casino, but has no other relationship with the Perth Casino?
The punctuation of paragraph A is unhappy, but my respectful contention, it would, although it is obviously an area where clarification would assist the regulatory regime. And I say that it would because if one takes the or to be disjunctive, a person in a centralised function who exercised a decision-making capacity through the exercise of a discretion, that regulated aspect of the operation of the casino. So to take as an example, Mr. Blackburn, to the extent he has a discretion in the exercise of decision-making functions over the AML CTF program to be employed in Burswood Casino, that would seem to fall within paragraph A. The complexity comes in understanding what, if any, approval mechanisms within the Burswood Limited entities might exist in relation to the approval of a discretionary decision that he might make. That is, are they axiomatically adopted? Is there a delegation out from those companies to him in relation to the exercise of that discretion, which is suggested by a centralised management function. That is, centralised functions operate because there is a delegation by the entity to the centralised function in relation to those matters.
Yes, so far as I'm concerned, there's nothing inherently problematic about a centralised process, but it has to be seen in the regulatory context. So it's really the impact on the regulatory context that's exercising my mind at the moment.
And I think we have addressed aspects of that in our submissions on the regulatory framework document, and that there is the scope for improvement in that area. Indeed, I think my recollection is we suggested the possibility that there might be a subcategory of what I call more than key employees, critical decision makers, who might require special attention in relation to probity and competence approval, potentially.
Can I move now to the topic of the remediation work and the remediation plan? And as you indicated, there are the more traditional and then the broader views, the first relating more to the people, the second to the systems. And as you indicated, this is not an easy area to work out, but it's something we have to do. But can I just, whether you're talking about the people or the systems, the reality is that we have to make decisions in a temporal context, like now, what's happening now. And if you're looking at an entrenched culture, we have to look at Crown both at the CRL level and at the Burswood entities level as it is now. And there has been radical change, both in terms of, or on one view, certainly in terms of the people, in the second half of 2021. And on one view of it, there's been radical change in many systems and a movement towards a program that, although it's going out for some time in the future, does have some definition to it. Now, in that sense, how do you characterise what might be termed an entrenched, almost, or bordering on irretrievable culture?
It avoids the question to say that is a very profound problem. Draw a bad analogy, the bomb's gone off, but we don't know what the damage is yet. We don't know where the debris landed. There's lots of activity. There's been lots of change. We don't know whether it has substantially changed the outcome. Now, Crown projects a very high degree of confidence, not only that it has changed things now, but that change will be ongoing. And from the GWC's perspective, it is probably more an issue of the prospect that that change will be ongoing to produce a result within a foreseeable and finite time. And then that those changes will stick in the longer term. And what regulatory tools are appropriate to observe, audit and address any deficiencies which emerge over time. I'd concede that I do not know how you can decide whether the level of cultural change which has occurred or is imminent is sufficient to remediate the past. But can I say this? It is Crown's position, as we understand it, is that it is easier for a company to change its character than an individual, because on the traditional Tesco view about corporate psyche, you change the people and therefore you change the mind of the company. The concern that we've identified, and I think the concern that you're grappling with, Commissioner, is that this is a large organisation. Much of what is done is not done by management. It's done at a level below management, and management may have changed, but have they instilled change in the individuals who will actually implement those changes and make them effective at an operational level? I suspect, and it is no more than a suspicion, that one could get to a level of comfort about the conclusion by saying, what are the changes which have been made or are planned? Do they manifest themselves operationally, that is, in process changes which are significant to address the strategic risks with which the Commission is concerned? And are there the signs of a will amongst the new corporate mind, adopting a Tesco approach, to drive that change regardless of the individuals? And part of that goes to a willingness to change out those individuals if they are not compliant. And of course, we've seen very significant change, not just at a board level, but at a level 1 and 2 layers below the board, in only the frankly, in the course of the submissions being drafted and put in. So if one made affirmative findings about the will, about the programs, and about the individuals charged with demonstrating that will and giving effect to those programs, then one might reach a conclusion that even if there are cultural difficulties in the short to medium term, those may well change as a result of the implementation of the change program. That's a complex calculus, which then raises the question, well, what if it doesn't happen within a reasonable time? And of course, that is fundamentally the question with which Commissioner Finkelstein grappled in Melbourne, and he devised a solution to that, which is, as you're aware, an ongoing monitoring, more than a monitoring role, a special manager is a quite extraordinary role, to see that expression of will and those programs in fact manifested themselves in change in a finite time period, and the legislation which has been adopted by the Victorian Parliament provides a firm mechanism for giving confidence about an outcome at a point in time in the foreseeable future.
Is just following on from that, the monitoring process, if we were to come to the view that something like that was desirable, is there any reason in principle why it couldn't be done through the regulator engaging a group such as has been done in New South Wales with Kroll?
No, I don't think there's any reason why it couldn't be done. I mean, ultimately the question is there a personal body with sufficient power to robustly interrogate the individuals, the systems and the process? It could actually be done by a roving commission effectively under the existing powers in the Casino Control Act, arguably. That is, the Minister directs a roving inquiry to that purpose. That would likely achieve the outcome of auditing the result, which is, I think, the paramount consideration. Where the Victorian approach has gone further, of course, is that there is an interorum component to the mechanism which they've adopted, both during its operation and at the end of its operation, because there is effectively a default cancellation of the casino licence unless a high bar assurance that the remediation has been effective is achieved.
Right, thank you very much, Mr Evans. That's all I have, and once again, thank you for your submissions. They have been of great assistance, and
Thank you, Commissioners.
1 o'clock,
1 o'clock,
2:15.
2:15. 2:15, Mr Dunmander.
Thank you, Commissioners.
We'll adjourn to 2:15.
All rise.